Hello and good morning. Welcome to the panel where enforcement is just a piece of the puzzle, the GDPR and the journalistic exemption. We are delighted you are joining us today, despite of what we heard of excellent party yesterday. We really appreciate your commitment. Our panel will focus on slightly different angle compared to yesterday's presentations. And when I was thinking about one word to describe it and to put it all together, that word would be intersection. It is nearly impossible for us to talk about the enforcement of the data protection law in the context of media and journalism without placing it in the broader context of democratic values and democratic processes, and without touching upon the intersection of data protection, privacy, freedom of expression, and freedom of information. Naturally, this also comes and leads to the intersection of different enforcement mechanisms which have historically developed in the member states and not on the supranational level. These are self-regulatory mechanisms, data protection authorities, in some cases, media authorities, and of course, the courts. Which leads us to the question as to where the data protection authorities find themselves at this intersection. How do they consider the democratic impact of their decisions on the broader public good? What about the divergent approaches to enforcement that are so different across the states? Should they be reconciled? My last remark here is you might find the running order of this panel slightly different to what you've seen in the previous days, and we were granted an exemption from the EDPS to do it slightly differently, just to make sure we provide a solid introduction into this topic and facilitate discussion and as well accept your questions at the end of the panel. And of course, the best thing about today is my panel of the speakers, and I couldn't have wished for the better panel. I'm delighted to be joined today by 3 speakers here with us on the stage and 1 speaker remotely online. Let me start with David Erdos, who is sitting right here. David is a co-director of the Center for Intellectual Property and Information Law at the University of Cambridge. And among other things, he's an author of the book, European Data Protection, Journalism and Traditional Publishers, Balancing the Tightrope. David's research explores the nature of the data protection, especially as it intersects with the right to privacy, freedom of information, freedom of expression, and freedom of research. Next, just to my left, is Shara Monteleone, who since 2019 serves as a legal officer at the Italian Data Protection Authority, Garante. Shara's background is in policy analysis and research with a specific focus on intersection of media and privacy laws. Our next speaker will join us online. Hopefully, he is waiting for us to connect. And this is, hi, Matthew. Good having you here.
Hi,
Matthew Caruana Galizia, who is the director of the Daphne Caruana Galizia Foundation, established in the memory of his mother, Daphne Caruana Galizia, a Maltese investigative journalist assassinated in 2017. The mission of the foundation is justice, journalism, and memory, and among other things, they work to support independent media and public interest litigation. Last but not least, here in the center is Renate Nikolay, head of cabinet of the Vice President for Values and Transparency, VЄра Jourová. From 2014 to 2019, she played a key role in the adoption of the data protection reform and the adoption of the Code of Conduct for platforms online hate speech. Currently, she works extensively on the issues of media pluralism, and we will hear more about that today. So, without further ado, let me introduce the first speaker, David, as mentioned. And I have a question to you, David. You have undertaken, by far, from what I know, the most extensive socio-legal empirical inquiry into the application of the data protection law, not only GDPR, but the Data Protection Directive and national data protection laws to journalistic expression. And yesterday, we've been hearing a lot about commercial context and enforcement in that field. What are those unique features of the data protection enforcement in the context of media and journalism that you have observed throughout your research? Would you share with us?
Well, there's quite a lot, Natalija. I don't know if you want me to go to my presentation.
Yes, please.
Immediately, but we can certainly in the discussion also pick up the discrete points. If I could have the slides and we could get going, or maybe I meant to
Yes, you're here.
To do
we
this
have them.
myself. Okay, excellent. Well, it's really great that EDPS, Boroni, Natalija has put on this session, and I think there's still some confusion to an extent as to why are we here early on a Friday morning, even discussing this. What is the relationship between data protection and journalism? And there is a strong relationship to start with because of the very material scope of data protection. Any information about even an identifiable individual, and that information doesn't have to be sensitive. It doesn't have to be private. It could be about someone's public role. It could actually be quite innocuous, and processing is anything on the digital device. Well, you begin to see that the interface, it's almost impossible that anything that journalists do isn't going to involve a considerable amount of things within the material scope of data protection. That's the interface, but then you get to the tension. The tension is very considerable too, because data protection very much has taken the kitchen sink approach. It's trying to put everything, all the rights and values which might be at risk in digital society, into a protective framework, privacy, reputation, fairness. And so you get default rules about the data protection principles, sure, fairness, legitimacy, these to some extent are journalistic ethics, but also transparency provisions, proactive privacy notices, which would, in theory, if applied, outlaw really investigative journalism, and they're not compatible with investigative journalism. Sensitive data rules, which start as a prohibition without waiver from the data subject, which really go through categories which are the most interesting from a journalistic point of view often: political opinion, religious belief, trade union issues, even things like health can be of public interest. And a sort of discipline provisions to do with the role of the regulator, which may fit the commercial world, but are hardly compatible with the idea of a free and lightly regulated media. So it's not surprising that we see, and these are important protective values as well, that we see data protection being invoked even in a journalistic context increasingly, because of this material scope and because of the sort of default provisions that really would help someone who faces heavy investigation or heavy difficulties, as they see it, with the media. And we may get to that when we look at things like the SLAP, the strategic litigation against public participation proposals later on in the session. However, and this is the next point, journalism has very special treatment in the GDPR. So Article 85(2) enables almost any provision, or in fact requires almost any of these provisions I've gone through, to be disabled if it's necessary for reconciling two fundamental rights: data protection, sure, but also freedom of expression. And Recital 153 provides, based on actually on Court of Justice case law, a little bit more context. Talks about the EU Charter, because in the EU there is a common rights framework. Emphasizes the need for journalism to be interpreted broadly. That's an issue I'm going to come back to. And also does emphasize that you only should look for certain provisions to be derogated from. It should be really case by case. It shouldn't be sort of across the board. So that very much places things back in the member states box. What has happened in the member state box? Well, let's look at substance and then let's look at procedure. The vast majority do subject journalism, I think rightly, to some qualified standards, some qualified expectations. This isn't a complete exemption. There's wide divergence, and still probably problematic divergence, ranging at the extremes for examples which clearly fit outside Article 85(2), I would say, from no explicit limitation being provided in the law, like in Croatia or Spain, through to complete exemption. Sweden would be an example. Supervision, we know that the idea of a data protection authority is a part of the fundamental right. There's not only court supervision to an extent, which is actually a mandatory requirement still in Article 85.2, but there's some DPA supervision in all member states, with some very interesting things in Lithuania and a few others where a specialist media body engages in that supervision. But with explicit legal limits in half the member states, it really should be 100%, given the auditing powers and things like this, which wouldn't really make sense in a journalistic context. So taking stock of all that, where are we at? Well, sorry, I should have flicked through onto that slide, but we're now onto this slide. Well, DPAs remain the guardians of data protection rights, even in the journalistic context. And that comes with standard setting and enforcement duties. But there are many challenges, many usual challenges which we're hearing about in this conference, but also many unusual challenges. So of course there's the resource challenge, yet another issue data protection authorities have to engage with. Yes, they're the legal issues, even the ones which we've been talking about in this conference as a whole, but then there's an additional one. There are 27 different regimes here. Really, genuinely 27, not just a few things here and there, but really quite fundamental differences. And there's also an epistemic challenge. You know, data protection authorities are not the experts on freedom of expression. They are the experts on the other fundamental rights. So in the last part, or the sort of second half of the presentation, I just want to run through some potential solutions. The first of which does sort of come from my book. How can data protection authorities square the circle here? Well, one way of thinking about it is whether they could try and develop a sort of a meta or co-regulatory approach to the media sphere. And that would be to try and encourage responsible self-regulation, because it's both in terms of the epistemic issues, but it's also the practical challenges. You know, they can't, well, some can try and they can be resourced, but most can't deal with hundreds upon hundreds of individual complaints in the journalistic area. If you could get an accredited body, potentially using codes of conduct and monitoring articles even in the GDPR, then a reasonable standard could apply. You know, it could be that body will deal with it and it only intervene in serious cases, or if there's clearly been a failure of reasonableness. You can look at a certain interaction with a non-accredited body, and hopefully reserve for a small number of cases where there's no self-regulatory body in the picture at all, where there will be a need for fully independent analysis. Now, the last thing I want to look at is the proverbial elephant in the room, which is a very important elephant, which is, what do you do about the citizen? I talked about journalism having to be interpreted broadly, quite rightly. Amateurs are journalists. Citizens are journalists. We can all potentially be journalists. A supervisory role there is very difficult to conceive. Would this overwhelm data protection authorities? Well, not necessarily, because the problem can potentially be mitigated in three ways. The core of the regulatory standards, co-regulatory standards being built up in this more traditional area, can actually help provide context to even the citizen media area. The number of genuinely impactful amateurs may be actually more manageable than simply saying everybody is a journalist. Yes, everyone can be a journalist, but how many actually are impactful journalists? More manageable issue. And probably the most controversial, but in a way the most important factor, is that most citizen journalists interact in a mediated format through platforms. And platforms can potentially play a similar co-regulatory role with oversight without invalidating the core of the fundamental freedoms. That would mean that it's only in the small number of cases where they're not in the picture and they're citizen journalists, you'd be back at the top of the pyramid. So I've been rattling through. If you want some more developed thoughts, do look at my book and some articles, but I will stop there because I don't want to engage in too much self-promotion here. And I'm very much looking forward to the discussion and the debate. So thank you very much.
Thank you so much, David. It's a brilliant book, so absolutely no self-promotion. I can also promote that one for you. But Sarah, let me turn to you right now and zoom in for a second kind of on the more practical experience of the National Data Protection Authority. So what David has remarked is that the DPAs remain the guardians of the data protection rights even in relation to journalism. Is that your position as well? And what enforcement examples can you bring to us from Garante's experience?
Yes, thank you, Natalija, and good morning, everyone. I also
It's
have
coming up.
yes, I also have some slides for my presentation. As I said, I will, and also anticipate by Natalija and David, I will focus on the experience of the Data Protection Authority, the Garante. It actually is the 25th anniversary this year of the Garante, so it's not so young, but not so old either. Why we focus on that? Because I think it's also important to consider the practical experience and the concrete cases. We always talk about balancing these two rights. I like to think more about these rights as a complementary, especially more and more that we go in a sort of data-driven society. Why? Because I think protecting data protection is also important, necessary in order to protect other fundamental rights. But I will come back later on that. First of all, in my talk, I will just have a quick look at the legal framework, the Italian legal framework, and then to some decisions, a couple of concrete cases to look at this derogation in three main fields, judicial and health data, so special categories of data, children's data, and journalistic investigation or investigative journalism. Oh, sorry, probably too fast. If I can come back.
The one on the left?
Yes.
Yes.
Yes. Okay. So as for the legal framework, as anticipated also by David, GDPR at Article 85 consider the possibility for member states actually say member states shall reconcile. Use this word actually twice in the same article. And is necessary when, of course, member states need to consider derogation to provide specific provisions when it's necessary to reconcile. So it's a kind of really obligation in order to protect and to balance these two rights. And in Italy, we have this Italian law, we call it Data Protection Code, that has been updated, of course, in 2018, and provide a specific part dedicated to journalistic activities, journalistic exemptions. It applies, these rules applies to all the journalistic activities, so not only to professional journalists, to freelance, but also, as David was saying before, also those who occasionally publish or disseminate articles or papers. Of course, the main problem is to have its dissemination of articles or papers that are essentially with the purpose of journalism. And so this is important to have the journalistic purposes in mind. But it applies to everyone, so also to citizen journalists, to bloggers, and so on. So the derogation, a specific regime that is foreseen in this data protection code. For instance, you don't need, as a journalist, you don't need to ask for consent for a special category of data, for so-called sensitive data. But still, is it necessary to respect the rule of conduct? And we have this rule of conduct since 1998. Again, it was updated in 2018. And it's a specific rule of conduct that has been adopted by the National Council of Journalists Association, but it was promoted by Garante and need to be approved by the authority, by the DPA. It's important because this rule of conduct contains specific provision and also, let's say, is a specify also other provisions that we can find in the regulation, the GDPR, and in the Italian law, the main law. But the important article is Article 2-quarter that say that data protection, of the Data Protection Code, they say that compliance with this rule of conduct is a condition for lawful processing. So that means that even if we have derogation, we have specific regime, but you need to respect the code of conduct. So just to have a quick look at the content, this rule of conduct starts with a reference to our Italian constitution. We don't have a specific article protecting data protection or privacy, also because our constitution dates back to 48. But we have a specific article 21 related to freedom of expression and journalistic activities. In particular, it says that journalistic profession cannot be subject to authorization or censorship. And it's clearly also because of the even historical past that we had. And importantly, also recognize to everyone the right to express freely its thoughts. So this is a freedom recognized to everyone. Article 2 of this rule of conduct in particular provides, as I said, protection for journalists, including sources. So journalist doesn't have to reveal the source of information, his or her information. So it's related to professional secrecy, but it's important that it's also stressed. And this could be considered to be balanced with, for instance, Article 15 of the GDPR, when you have access, right to access to information. But this derogation need, of course, to have considered to be against some criteria, some specific criteria. That is the essentiality of information. The information needs to be essential regarding fact of public interest. That means that this is a condition in order for this derogation to apply. And that means also that if the information is considered to be essential, this is not considered to be in contrast with the respect of private sphere. And then there are other important provisions regarding protection of dignity, protection of non-discrimination principle, or protection of children. Okay, just to have a quick look at some specific cases. The first one relates to derogation in the field of special categories of data, like judicial or health data. Again, these derogations are foreseen in the code, but still they need to be to have in place some safeguards to respect the rule of conduct. And these, for instance, mean that in a couple of decisions, the guarantee decides that specific concrete situation, specific, for instance, video or a picture that had been published or broadcasted was not considered to be essential. The information that had been provided in this specific material was not considered to be essential, as we said before, for the public interest. And it was a case of a guy who was actually doing some self-harm act to himself, so it was kind of violent to himself in a police station, actually. Even if at the beginning, the same police station was saying that it was trying to show that it was himself doing that. I mean, it was provoking this kind of harm by himself and not by police. So it was in some way considered to be a sort of a public interest, also because of, unfortunately, some other example, bad example that happened in Italy inside the police. But still, the guarantee thought and recognized that was some details, some also details that could bring to identify this subject was not essential. Another case, for instance, was also considered to be against the principle of dignity, the protection of dignity of the person, when some image or video were showing people in a detention status, so inside a police station. Or, for instance, many times happened that data subject complained because their names or their image appear several times in website or articles, because the beginning were the suspect, and then we had an evolution of the criminal proceeding, and then it was proved that it was innocent, but it was still identified as suspect of even mafia in application. So in that case also, we considered that the guarantee considered that it was not in the public interest to indicate some specific details, but also that was outdated and was not accurate, the kind of information that was provided. So as a measure, it was adopted, first of all, a temporary limitation of the data processing, then a ban and a reprimand to the publisher. As another experience, of course, another example is regarding children. Here, the rules are quite clear. The children interest had to be considered as a predominant. A couple of cases, for instance, the guarantee just stressed the importance of take into account the child interest. Sometimes they are just mentioned because of the parent's public role. And that was, again, considered not essential and stressed again the importance to protect the child. So again, a ban, a reprimand. I would like to stress the fact that especially in this field, in this sector, the Garante tried not to give too many fines. I mean, they didn't adopt many monetary sanctions, monetary fines. But still, we have also other cases, and I will come to the third part of my presentation that relate to journalistic investigation. So in this case, as I said, Article 2 of the Rule of Conduct provide for derogation and also, for instance, simplify information. That means that the journalist is not obliged to give all the information that is foreseen in the GDPR. It can even give a simplified information about his identity. Usually they should, except when it is either unsafe for himself or herself, so when it's risky for his life, or even when this could be against even the exercise of the information role. So when it's making possible to exercise the information role, then you're allowed even to hide the name or even the journalistic purposes. So it's recognized sometimes, for instance, that hidden camera or not provide the identity of the journalist is considered to be okay. Still, you need to adopt some safeguards as much as possible, including, for instance, anonymity. You can show even, it was several times in a TV broadcasting, showing all this interview of a doctor, for instance, but it was clearly possible to identify this subject, even especially for the contest in a small town, and it was not anonymized. It was possible to recognize him from his voice or from what we was saying. So in that case, the Garante decided to issue a fine of €20,000 to this TV broadcasting. On the other hand, we had actually other situation in which it was considered to be in the public interest instead to publish even religious data. For instance, was a religious sect, and there was a link between this religious sect and what happened afterwards to somebody. And in that case, the Garante decided that this was in the public interest, or video or picture, for instance, supporting a report on illegal employment. In that case, the data protection claims were considered to be unfounded, so not justified. And that means that the balance in this way was more on the journalistic side. And I conclude, just say that data protection need always to be considered as let's say, an instrument to protect other fundamental rights, especially freedom of expression, and not, let's say, an excuse not to protect or to limit even our freedom. Thank you.
Thank you so much, Sarah. That was really interesting and instructive to understand practical examples from the Data Protection Authority enforcement. Now, we are going to move from this stage to teletransport to Malta, hopefully seeing Matthew right now on the screen. Can you hear us, Matthew, and see us?
Hey there, yes, I can hear you.
That's great. Welcome to the panel. I will soon pass the virtual floor to you. And now we have heard a perspective from academia, from David, from practical experience, from the regulator, from Sarah. So Matthew, 4 years into GDPR enforcement, what challenges do you, as a more representative of, let's say, journalistic community, working to support independent media, observe when it comes to the application of the data protection law to journalistic expression? Would you share that with us?
So thank you for the question, and thank you for having me on the panel. I mean, while I do come from a purely journalistic and tech or IT background, the foundation that I now run also does a lot of legal work. And one of the cases that we're working on currently is a class action or collective action lawsuit against a company that was collecting information on voters in Malta. So we kind of work on both sides. I mean, we receive privacy complaints and we also make them. So that's where I guess I'm a representative of both communities, the one working sort of towards legal accountability for privacy violations, and the one working for accountability in the journalistic sense. I mean, while I have worried quite a lot about you know, the GDPR, the privacy complaints that we receive, both for the work that my mother did in her past, because one of the foundation's responsibilities is safeguarding my mother's journalistic work, and that includes her website. So we do receive some complaints, for example, from Italy. I mean, from Italians particularly, especially those who have been reported on as having links to organized crime. Most recently, we did do one big investigation about the sale of passports in Malta, Cyprus, the Caribbean, and beyond. And we had to fight back against a privacy complaint from the firm where the leak came from. But I am a bit more worried that we are kind of generally going backwards when it comes to openness of data. For example, with Malta's corporate registry and Malta's court registry, the GDPR has been used to make it much less open than it was previously, for example, 10 years ago. Just a couple of years ago, journalists could easily search the company registry by address, could click on a single person's name in the company registry and see the other companies that that person had registered, whether they were Maltese, foreign, or whatever. With the criminal courts, we could see most criminal court judgments. Now they are being removed upon request from the defendant, even where they have been convicted. And the reason that is given by the state each time is GDPR. So while there is an exemption for journalistic activity, what the state is now doing is kind of augmenting the GDPR to make sources of information that journalists have depended on in the past less open. So what is in fact happening is that our kind of water supply is being cut off. With less access to information, we are thereby less able to report on what is happening. And as a result of that, obviously, the privacy complaints go down. But this is only because we are much less able to access sources of information. And in fact, I've just come from our civil court, where the foundation has filed a case about access to information in Malta, claiming that there is a culture of opacity in the country that has increased over the past couple of years. And just yesterday, we had an event here with representatives from Malta's corporate registry, where this subject came up quite frequently. All journalists here bring it up. There is a huge problem with access to information. And the reason that is given by the state, by the government each time, is that these are new rights under the GDPR. We have to restrict everyone's access to sources of information. So even though we have had AMLD 3, 4, 5, and now 6, which has put an obligation on registries to make more information on companies public, overall, the levels of access of journalists have gone down, I would say. And the reason given is always GDPR. We are left with no recourse in these cases. There is nothing we can do except kind of political level advocacy to get our rights back as journalists and as members of the public, in a sense. But I am worried that we are regressing. I am aware that in certain countries in the European Union, for example, Germany, it has always been difficult from the get-go, for example, to get company information, to get copies of court judgments. But in Malta, it has never been that difficult. there is a cultural difference. And what I am worried about is that the GDPR is kind of changing a culture of openness that perhaps Malta had in the past with information from courts, information in company registries, and reducing it to the kind of denominator of more established European democracies, which is one of increased secrecy or increased opacity. So we risk losing that openness, which is perhaps the one good thing that our democracy had.
Thank you, Matthew. Thank you for bringing up the intersection not only between freedom of expression and data protection, but also freedom of information and data protection, which adds an angle to our discussion, and we can take some questions afterwards. Please stay with us. We have last intervention from Renate, and then we're going to open the floor to our audience. But Renate, let me turn to you right now. Matthew has raised issues that media organizations or also perhaps broader than media organizations, nonprofit organizations are facing on the ground. And David has earlier pointed to the divergent approaches to enforcement across the member states. GDPR in itself clearly leaves a broad margin of appreciation for the member states. So I guess just curious, is that by design? If you can recall those discussions from back in the days. And what trends do you today see, what does the Commission observe today, and what regulatory interventions are in the pipeline to address some of the things that have been raised here?
Thank you very much for having me and for giving me the floor. Indeed, I was involved in the negotiations on the GDPR, and I remember very well the difficulty we had around Article 85, where I would say in the end what we did was consciously leave a lot of space for member states to specify the reconciliation work that has been described very well by earlier speakers that is necessary when you are dealing with different fundamental rights. And that was done on purpose because we could early on see that we were clashing with certain constitutional kind of traditions, even in member states. And you know, with the GDPR being a very innovative kind of, you know, piece of legislation, but at the same time very horizontal and broad also in terms of, you know, paving the way for a digital transition, I think that was the utmost we could do. But of course, it has led to what, you know, earlier speakers said, and in particular what David's research has shown, that there is huge fragmentation. And also that we observe that DPAs, not all, are as active as the Italian one. And if you look at the board, there has been very much reluctance to actually engage in kind of, you know, clarifications because, you know, we have done a lot, or the board has done a lot of guidance instruments because this is a, you know, future-proof regulatory approach with the GDPR, but we have seen less of that in this kind of specific area of Article 85. But I wouldn't see that as a kind of the key challenge for, you know, what we see at the moment when it comes to, let's say, the broader aspects of media freedom and media pluralism, and whether what we should really focus on is now to have guidance on Article 85. I think no. I think what we are observing at the moment, and here that's what I wanted to bring into the debate in particular, is a much broader kind of, you know, regression and backtracking on the broader aspects of media freedom and media pluralism. And let me kind of, you know, bring you on a journey on that. So for the last 2 years, we have engaged in something pretty new in the EU. We're doing annual rule of law reports on all member states. This has to do with our broader work on you know, rule of law problems that we have in certain member states. And we wanted to have an instrument where we look at, you know, in a preventive way at all member state situations, but with a very broad concept on rule of law. So this does not only look at what you would expect, the independence of the judiciary or the framework to kind of deal with corruption. No, we are having a specific chapter on media freedom and media pluralism. And it's very much fed by, you know, the decade of experience that we have with the Florence Institute that does a regular media pluralism monitor of the member states, and even going beyond the member states, even looking at some of the Western Balkans partners. And it's very interesting to kind of see the evolution of this rule of law report. We're just in the finalization of the 3rd edition that's coming out mid-July, so watch the space on that, because you see a narrative evolving, and you also see that we really have issues in many member states, whether it's kind of, transparency on the ownership of media, whether it's concentration, whether it's editorial independence, whether it's governance structure, whether it's safety of journalists. So it's pretty, broad. The second kind of, aspect that I wanted to bring in when we are talking about media freedom in the EU today is that we are seeing very worrying trends regarding the safety of journalists. We have in the EU cases of, murdered journalists. We have seen a trend, especially also in the context of COVID, of having more difficulty for journalists, for instance, in demonstrations, to do their work properly. Sorry. So this is a trend that is not particular for 2 or 3 countries only. That is really a trend that is much broader. I think the third point why we are putting more attention to that is also that in the structure of this commission, we have for the first time a vice president being able to pull all the different strings on the kind of the media policy, and that's the vice president I'm leading the cabinet of. So what have we planned, or what are we doing to address these matters beyond what we have already in the GDPR with the exemption? We will continue, as I said, with a very detailed monitoring. This year's rule of law report will for the first time have concrete recommendations to member states. So that's a kind of iterative process. And that will help us to kind of, develop the narrative even further with the member states. It's a very kind of cooperative process with member states. It's not something that we design, the rule of law reports from our ivory tower here in Brussels. There's a lot of interaction with member states authorities, the government authorities, but also a lot of the other stakeholders to kind of inspire and inform our input. But we have also embarked on concrete legal action. And here I wanted to remark 3 points. The first was because we were really shocked about the safety of journalists phenomenon that is on the rise and the attacks. So last September, we, because this is a new area of work for the European institutions, so we have to treat it carefully. There are also kind of, in the structure of our constitutional framework, quite some kind of, limitations in terms of the competence of the EU institutions in this area, and member states watch this very carefully. That's why we kind of, have to do it step by step. So last year, we adopted a recommendation on the safety of journalists. And I'm very happy that next week, under the French presidency in the General Affairs Council, we will have conclusions on that. Reinforcing that, because recommendation from the side of the Commission is a soft law approach, but when it's accompanied by conclusions from the Council of Ministers, that means people are taking it seriously and are following up. So that's very good. We have at the end of April come up with a legislative initiative to address the so-called SLAPs that David already mentions. So abusive strategic litigation with the purpose of having a chilling effect of journalism. We see that phenomenon to be on the rise as well. Also there, we had to be, targeted in our approach, what we kind of legislate on, where we have competence for. That's why we came up with a directive that addresses cross-border civil cases. And the main kind of, gist of it is that we want that courts everywhere in the EU will have a possibility for an early dismissal. Because what's very difficult in these SLAPs is very often they are won by the journalists in the end. But it's the kind of the dreadful length of kind of the proceedings. It's the energy it sucks. It's kind of very often the chilling effect it has when we're talking about books being in the preparation. Some of these books are never kind of written in the end, because if you don't have a big publishing house in your back to support you in this SLAP kind of, proceeding, you will end up not being able to defend yourself well. So the early dismissal seemed to us to really be the kind of, turning point to kind of make it harder, because it's very often unequal kind of players. Very often it's kind of a David Goliath kind of scenario. To make it harder to bring cases. On the other hand, of course, access to justice exists for all. So, of course, these cases should not be forbidden. That's also something that we have to reconcile, since we are in the area of reconciling different rights. And we're in the beginning of the interinstitutional process on that. I'm quite confident that we will get there, because we have a targeted approach. It's accompanied, again, by a recommendation that looks at the phenomenon in a broader way, that recommends to member states to treat also domestic cases in a similar way, that recommends to member states to treat defamation not as a criminal kind of, charge, because we have a fragmentation of how this is dealt with. So really to have a more level playing field, because of the moment, what we see in SLAPs is a lot of forum shopping going on. And we also protect against the third countries by the way of, not obliging our courts to recognize these judgments, because very often you had cases where, and I think that was also the case of Madame Caruana Galizia, that would even go beyond the end of the EU borders, the defamation cases. So this is an important and innovative new piece of work where we had to kind of find the competence that we have and be targeted. And the third one is an even more ambitious piece of work that we are at the moment involved in, and that's the Future Media Freedom Act. So for the September State of the Union address, we hope to have it ready. This would be the first horizontal piece of legislation coming from the European Union. It would be a principle-based approach to really kind of create safeguards all over the EU for editorial independence, for transparency of ownership, safeguards to kind of, help us to identify trends when we see that there is in a certain country a renationalization trend of media companies, to kind of see, is this an issue that we worry about from a media pluralism angle? If we see that in another country there is a clear public kind of hook into, the councils of public media, that we have kind of, criteria that we have agreed on together to kind of intervene. It will be accompanied by a supervisory structure and will really help us to kind of, deal with the horizontal theme of media pluralism in the EU, which is also an aspect for the internal market, because it's an aspect also of whether kind of media operators can work everywhere under the same conditions in the EU, to deal with that in a more substantial way and a more coherent way. So that's the outlook I wanted to give to you. Maybe kind of, three final points from my side. I think the debate has really moved on compared to the GDPR kind of context on kind of, the freedom of the information space, so to say. The platforms were mentioned. And I think what we have much more, to look at in the future is to have a kind of, a regulatory approach that will facilitate in a harmony the interventions of the different regulators. Because we will have, with the Digital Services Act, which is our new masterpiece on digital rulemaking in the EU, a very strong hook on kind of addressing the platform accountability. And there will be, the Commission or the digital service coordinators working on that. There will be maybe one day with our Media Freedom Act, a supervisory structure coming for media freedom. So I think we will have a challenge in the future to make that kind of, supervisory structure and architecture actually work in harmony. And we will have to look at memoranda of understanding and things like that to make that work. And the other last point, and that very much kind of links with what we heard also, that in some countries here, Malta, there's an issue of access to information. I think the whole approach on kind of the need for access to data will be a much more growing kind of, aspect when we want to keep our information space healthy. Healthy in the sense of kind of be kind of, protected against massive manipulation, fake news, foreign interference. I mean, we have to kind of talk about that as well, especially in the current times of the Ukraine war, where we see that Russian propaganda is abusing media outlets to actually pursue that. So I think these are the challenges that I see, how we, that we have to address in moving forward in reconciling all these different aspects. Thank you very much.
Thank you so much. And I think the point that you have raised, especially at the end regarding potential intersection between media regulators and data protection authorities is really interesting one. In a lot of countries, it's dealt currently on kind of case-by-case national level, depending on the regulatory structure, but that could be the challenge if we speak about the topic of the conference for the future enforcement, right, and how it's going to look like. I actually had a question to the panel, but now looking at the time, just so everyone's aware, we have around 9-10 minutes to conclude that. So I would like to turn to the audience and see if we have inquiries or questions here before I go to mine. Yes, one over here, please. Could you introduce yourself?
Yeah, my name is Daniel Westman. I'm from Sweden. I'm a private practicing lawyer, but I'm a background in the academic world. I have a question. You talked a lot about leaving room for the national variations when it comes to Article 85, and I agree a lot with that. But then we have transborder, journalism is often transborder, and then we have, can you say something about which national implementation about the interface between data protection and freedom of speech that is relevant when we have transborder issues? Maybe an issue for David.
Thank you. Just to see if we have more questions and we should take them together. All right, let's start with this one. David, you're happy to start?
Yeah, I mean, there is actually a recital provision in the GDPR which does say, just in the sort of special expression journalistic context, that it's the law of the establishment of the journalists that would be applicable. Of course, that's probably close to what the law would be generally, actually. It doesn't resolve every issue because, well, for a number of things. One, what do you do with people who are outside jurisdiction? And they have actually been cases where you're talking about the provision of services potentially, or the targeting of individuals in the union. So they're all the extraterritorial issues which aren't resolved by that recital. And of course, you can have multiple establishments, co-controllers, and those sorts of things. But the starting point is that it's home country regulation, which I think makes sense given what Renate said about the cultural divergences, but does depend on a degree of harmonization, which the court has probably been doing a fair amount on. Even in the citizen journalistic context, there's been a case called Bovids to do with YouTube, actually, in a YouTube video. And it might be that the court will intervene further at some point, actually.
Anyone else from the panel? No. Good. Any more questions from the audience? Yekaterina, please.
Thank you very much. I represent Latvian DPA. And I have a question for all for you. Maybe you have thoughts and ideas, because there is GDPR and there is this duty of the DPA to enforce GDPR as well for the journalistic purposes, what we saw as well, like practice of Garantia. But there is new legislation, which was mentioned as well, which is much more broader and which possibly would require another regulator or self-regulator of the media. So what would be the interaction between two of them? Is it possible, for example, in the future then give all these powers to this self-regulator media and out of the DPA? Because as DPA, what I'm afraid always when we are looking at these cases, that we are becoming censorship of the journalist, and we are saying what is allowed it and what is not allowed, and that is what bothered me. So what is your ideas about this interaction and maybe coherent approach? Thank you.
Well, I think you point, the finger in the wound that, when you're dealing with, media freedom or, freedom of expression, we really have to be very, very careful not to go into content moderation. We really have to be super careful that we kind of, do not decide what kind of, opinion we like or we don't like. Of course, there's the reconciliation of different rights. That is the daily practice of constitutional lawyers, of courts, to deal with that. But I think, and there is a delineation, and this is very much pursued in our new digital rule book making, what is illegal, and this builds on what we have done in the past, because in the past we tried, so we had the data protection rules as the foundation. We then had the new phenomena in the digital transition of harmful content for the society. For instance, in 2015, we had, in the middle of the big migration crisis and the terrorist attacks, we had a huge kind of radicalization on the internet. So we had to kind of deal with that. And that's why we came up with the code of conduct against online illegal hate speech. Because that was very theoretical, because it was the illegal hate speech. It was what in all 27 member states was already recognized as illegal. Of course, there are borderline cases, but nevertheless, and that has now been found, has been transformed into hard law with the Digital Services Act. In the future, platforms will be held accountable for that, will be fined, there are huge sanctions, similar system, but different indeed regulator. So how do I see the future? That was one of the last points. I think we're not at the end of this. I think we're really at the beginning of a next phase in our digital transition journey, which is wonderful, which is very kind of disruptive in many regards for economies, for societies, where we all have to kind of adjust. And I think there will be a role for DPAs because we have data protection rights that kind of come into play. But I think when you're looking at the real core of, this kind of freedom of expression and securing freedom of expression against the kind of, potential challenges in a digital transition, where everybody can be a journalist, where you have the kind of, platforms with the echo chambering, the amplification, the speed, we have to slightly open that door, because that's really not the expertise of DPAs, at least not yet. And knowing very well the resources situation in DPAs, because we kept on sending letters and letters and letters to the ministers of finance to kind of make sure that the DPAs in the member states are well staffed. And I know you're all struggling with that. I think we have to kind of look at that. At the moment, we are seeing the mushrooming of different regulatory structures. We're seeing a different phenomenon even. We're seeing a more concentration of enforcement. In the Digital Services Act, also something to bear in mind, for the very large online platforms, it's not the national regulators in the end who will be in charge. It's going to be the Commission. So it's a totally new kind of role for the Commission. So I think the next decade, we will see, once we have all these rules under the roof really, and in place, I think we will have to look at the regulatory context, starting with what I believe is already a very strong trend to kind of make the intersection or the cooperation easier. Memoranda of understanding can help here. This was also something that my VP said in her speech yesterday, so I think that's a very important trend. But in the end, we will probably also have to refigurate some things.
But let me just pick up on that, since we have to conclude our panel, but I really liked your future outlook. So can I just throw this question to all of the panelists? What is you, if you would have a crystal ball or a wish list, speaking about data protection authority enforcement in the space of media and journalism, what would be on your wish list in terms of the enforcement? And when I say enforcement, perhaps let's look at that a bit broader as the enforcement toolbox, not necessarily the inspections and investigations that we focused on the first day, but there are definitely more tools out there. David, let's start with you.
Thank you, Natalija.
Sorry for putting you on the spot.
Well, yes, I'm happy with that. I mean, Renate talked about sort of a holistic approach, and I think we're only at the foothills of that in data protection, actually. Somehow we've got to bring together the thinking we've been doing on platforms. There's been the search engine case back in 2014, with the citizen media, with the sort of traditional journalistic landscape as well, and bring some sort of coherence to that in a way that is principled and also that is manageable for the data protection authorities. And yes, that might involve a specialist regulator with memorandums of understanding and that sort of thing. But it also, I think, must involve a role for meta or co-regulation. I mean, there are many challenges here. Maybe I'll just sort of close on this. Yes, I'm a huge advocate for freedom of expression, but we shouldn't forget that the digital world has brought enormous risks and, in concrete cases, enormous harms to individuals of being reputation, inaccurate data, very unfair, being disseminated at speed with no real accountability, the complete opaqueness of someone's private life, which has absolutely no public interest, being blasted around and being unable to ever rectify that. These are really serious issues which are within the scope of data protection. So I think there is a role for data protection. And let's be clear that the completely anarchic nature of many of these platforms has been a spreader of that. And it's also been a spreader of misinformation and some of the disinformation that we're seeing. So they are real governance issues. And I think data protection does have a role, and data protection authorities, whether through specialist agencies or working on their own, have a role. But it's really now moving to the next level beyond these sort of cases like Google Spain or what's been going on with the journalistic exemption, to try and bring some kind of coherence to this this space, which can provide certainty for both expressors and which we can both be at the same time, and also data subjects.
Thank you, David. Shara, what about you? What do you think? What's the wish list for the future of the DP enforcement?
I don't have a kind of a wish list, but just quickly, what I just would like to stress again is that at least my hope is again to consider this kind of data, and so the enforcement tool for this kind of rights, data protection again, and other fundamental rights, not always as the opposite right, but again as complementary. So thinking also a kind of a shift in the mentality in the culture, in the sense to consider data protection as an instrument rather than as a limitation to other fundamental rights. And I think this is more and more the case, because if we think about artificial intelligence algorithms, how sometimes we think that this kind of new, already real society is already limiting us in some way. So protecting or ensuring data protection is also ensuring our freedom of thought, our freedom of expression. So my wish is also that these two kind of rights, and that means the relative regulators, should go together, should work together, should be also complementary. In some way, already it happens, at least in some member states. For instance, in Italy, we have the antitrust authority, the authority for the communication, data protection authority. You have already a sort of a collaboration in some specific case. But I agree that there is we need, of course, to go farther and
to mature that.
And
yes.
Yeah, probably to look for probably to change also in the regulatory framework. Yeah.
Thank you so much. And Matthew, you are the one to conclude this panel with your final thoughts on the future. Give us what you have.
While I really thank the Commission for the work that it has done on the proposed anti-SLAPP directive, and because this applies to any kind of action, including administrative action, then it protects us even in cases of GDPR complaints where the complaint is manifestly unfounded. So I think this the initiative of the Commission goes a long way towards establishing better protections for journalists against the abuse of loopholes, let's say, or abuse of process. But I also think that one way to kind of balance out the perhaps unintended consequences of GDPR is to make more of an effort on to make more of a multilateral effort, I think, to increasing openness of information. It's really disappointing that so few member states have ratified the Aarhus Convention, for example, and especially member states which preach and encourage a culture of openness and access to information. So I think this is one way to balance out the unintended effects of a sort of contraction of openness of information. Having said that, I fully agree with the efforts to make platforms accountable. But what we're saying is let's not throw the baby out with the bathwater.
Thank you so much. Thank you, Matthew. Thank you, David. Thank you, Renate. And thank you, Shara, for joining me today to discuss the question of journalistic exemption. And I think we actually went much broader than that, which, as I mentioned, it's inadvertently these discussions end up talking about democracy, democratic processes, and the intersection of fundamental rights. Thank you to the EDPS for having this panel at the conference on the future of enforcement, because clearly it has brought up issues that haven't been discussed in other panels just yet. Thank you for the audience for joining us. Thank you specifically to Veronique Chimina from the EDPS for taking this whole organization on her. We really appreciate that. I've been asked to inform everyone that 11:45 sharp, in the auditorium, there will be a keynote speech of the Wojciech Wiewiórowski, European Data Protection Supervisor. Please join him, and right now we'll have a coffee break.
Thank you, Natalija.
Thank you.